Patricia is a United Airlines flight attendant who flew out of O'Hare for 9 years. A turbulence event over the Rockies tore her shoulder apart. Illinois workers' comp law may be exactly where her case belongs, even though she lives in Denver now. She's already been through the airline's internal process, seen their doctors, and received their offer. It feels low. What she doesn't know is that the process she just went through was specifically designed not to tell her about Illinois. That jurisdictional fact could be worth tens of thousands of dollars, more than what's on the table. Most flight attendants never find out until someone tells them directly. Let me start with the question that probably brought you here. Why Illinois? If you're a flight attendant who lives in another state, it may seem strange that Illinois workers' comp has any relevance to your case. But for a specific and significant group of flight attendants, it absolutely does. Understanding that jurisdictional question can be the difference between a fair outcome and leaving real money on the table. Under the Illinois Workers' Compensation Act, a worker may be entitled to file a claim in Illinois if their employment contract was made in Illinois, or if they were hired in Illinois. That's the jurisdictional hook. United Airlines was headquartered in Chicago and operated out of O'Hare for decades. Thousands of flight attendants were hired through Chicago operations. Those workers, if they've since transferred bases, moved to other states, or relocated after retirement, may have the right to file workers' comp claims in Illinois regardless of where they currently live or where the specific injury occurred. The key factual question is where the contract of hire was formed. That determination is fact-specific and worth a conversation with an attorney before you assume Illinois doesn't apply to you. This isn't a loophole. It's a legitimate jurisdictional basis that Illinois courts and the Illinois Workers' Compensation Commission have recognized and applied. It matters because Illinois workers' comp law is generally more favorable to injured workers than the laws in many other states. That's why flight attendants from Colorado, Texas, Florida call a Chicago attorney. The jurisdiction is real. The advantage is real. And most flight attendants never find out about it until someone tells them. Now let me explain why airline workers' comp cases are different from a standard workers' comp claim in Illinois. Because they're categorically different. When a warehouse worker at a distribution center gets hurt and files a claim, they're dealing with an insurance carrier that runs a predictable process. Aggressive, yes, but familiar. When a flight attendant at United Airlines gets hurt, they're dealing with one of the largest corporations in the world, a company with in-house legal teams, sophisticated risk management departments, a claim process they control from start to finish, and decades of institutional experience minimizing the cost of employee injury claims. The scale of the opposition is categorically different. The resources they bring are categorically different. And the process they put flight attendants through reflects that. Here's the part Patricia was never told. In my experience handling these cases, the airline's internal injury reporting and case management process is not set up as a neutral system to maximize your recovery. It's a system designed to manage the cost of injury claims. The doctors in that system are selected by the airline. Referrals and evaluations occur within a framework the airline controls. The occupational health assessments that determine when you're fit to fly and when you can return to duty are conducted by medical professionals who have a financial relationship with the airline. The settlement offer that comes out of this process is a starting point, not a conclusion. In my experience handling hundreds of cases, the initial offer from the airline's internal process rarely reflects the full value of what the case is worth under Illinois workers' compensation law. Here's a question I already know the answer to, but I want to hear from you directly. Did anyone inside the airline's process ever mention that you might have Illinois workers' comp rights? Drop it in the comments. I've handled hundreds of these cases. The answer is almost never yes. But tell me what you've experienced. Flight attendants sustain real, documented injuries on the job. These aren't speculative claims. Shoulder injuries from lifting passenger luggage into overhead bins. repeatedly on back-to-back flights over years. The kind of cumulative damage that eventually causes tears requiring surgery, back injuries from working in cramped galley spaces, bending and reaching in moving environment, knee and ankle injuries from variable floor conditions on aircraft in constant motion, trauma from turbulent events where the forces involved can be severe. These injuries affect whether a flight attendant can continue in their career. And that's the factor that drives case value in a way that airlines process consistently underestimates. A shoulder injury that limits overhead reach is not a minor inconvenience for a flight attendant. It's a condition that directly impairs the core physical requirement of the job. When permanent impairment of that kind is properly documented and evaluated under the Illinois Schedule of Injuries, the PPD value is significant. It's not what the airline's internal number tends to reflect. The IME dynamic in airline cases is also critical to understand. In the airline context, just as in standard workers' comp, you will almost certainly be directed to an independent medical examination. The IME doctors in airline cases may have referral relationships with the airline or their insurance carrier. Their reports directly impact whether you're cleared to return to flying duties and the value assigned to your injury claim. Your own treating physician's opinions and the thoroughness of your medical documentation throughout your recovery are your most important assets in contesting an unfavorable evaluation. This is true whether your case moves through the airline's internal process or through the Illinois Workers' Compensation Commission. Here's what you need to do before you sign anything. You do not have to accept what the airline's internal process produces. You have a right to consult an independent attorney. You have a right to choose your own treating physicians within the statutory framework. And depending on where you were hired, you may have the right to file a workers' comp claim in Illinois, where the legal framework is more favorable to you. Call a Chicago attorney before you sign anything. The consultation is free. The jurisdiction question is worth exploring. The difference between what the airline's process produces and what a properly presented Illinois workers' comp claim can recover is often substantial. I've handled hundreds of United Airlines flight attendant cases. I know this specific opposition, these specific dynamics, and this specific process better than most attorneys in Illinois. That experience is what you're calling for when you reach out. Don't sign until you know where you stand. If you've received an offer and want to understand what contesting it looks like, watch my video on what an IME is, what the exam the airline schedules is exactly, what the video covers. Subscribe so you don't miss what we release. And if you're a flight attendant with an open claim, call Connolly Injury Law. Free consultation, no pressure. Were you ever told you had Illinois workers' comp rights? Drop your experience in the comments.